with Justice Ruth Bader Ginsburg in the Lawyers' Lounge of the Supreme Court. What is the majority opinion or dissent that you've written that you think has done the most to advance civil liberties?
Jeff, it's like saying, which of my 4 grandchildren do I prefer? There have been so many. Well, in the women's rights area, you can think of the Virginia Military Institute case. So many people said to me, why would women want to go to that school? I wouldn't, and perhaps you, a man, wouldn't either. But there are women who are fully ready, willing, and able to have that form of education, so why should they be held back by artificial barriers? I must say that the VMI case was preceded many years earlier by Justice O'Connor's decision, her very first year on the bench, in a case called Mississippi University for Women against Hogan. That was a case about a man who wanted to go to Mississippi University for Women to take nursing. It was the best nursing school in the area, but he couldn't go because he was a man. Same with VMI later on.
United States v. Virginia. Petitioner, United States. Location, Virginia Military Institute. Respondent, Virginia. Docket number 94-1941. Decided by the Rehnquist Court, Lower Court, United States Court of Appeals for the Fourth Circuit. Citation 518 U.S. 515, 1996. Argued January 17th, 1996. Decided June 26, 1996. Advocates Paul Bender argued the cause for the United States. Theodore B. Olson argued the cause on behalf of Virginia, etc. Facts of the case are, the Virginia Military Institute, VMI, boasted a long and proud tradition as Virginia's only exclusively male public undergraduate higher learning institution. The United States brought suit against Virginia and VMI, alleging that the school's male-only admissions policy was unconstitutional, insofar as it violated the 14th Amendment's Equal Protection Clause. On appeal from District Court's ruling favoring VMI, the Fourth Circuit reversed. It found VMI's admission policy to be unconstitutional. Virginia, in response to the Fourth Circuit's reversal, proposed to create the Virginia Women's Institute for Leadership, VWIL, as a parallel program for the women. On appeal from the District Court's affirmation of the plan, the Fourth Circuit ruled that despite the difference in prestige between VMI and VWIL, the two programs would offer substantively comparable educational benefits. The United States appealed to the Supreme Court. Question: does Virginia's creation of a women's-only academy as a comparable program to a male-only academy satisfy the 14th Amendment's Equal Protection Clause? Conclusion: 7-1 decision for the United States, majority opinion by Ruth Bader Ginsburg. On this court was the Honorable William Rehnquist, Justice Stevens, Justice O'Connor, Justice Antonin Scalia, Justice Kennedy, Justice Soter, Justice Thomas, who recused himself, Justice Ginsburg, and Justice Breyer. In a 7-1 decision, once again, the court held that VMI's male-only admissions policy was unconstitutional because it failed to show exceedingly persuasive justification for VMI's gender-based admissions policy. Virginia violated the 14th Amendment's Equal Protection Clause. Virginia failed to support its claim that single-sex education contributes to educational diversity because it did not show that VMI's male-only admissions policy was created or maintained in order to further educational diversity. Furthermore, Virginia's VWIL could not offer women the same benefits as VMI offered men. The VWIL would not provide women with the same rigorous military training, faculty, course, facilities, financial opportunities, or alumni reputation and connections that VMI affords its male cadets. Finally, the Fourth Circuit's substantive comparability between VMI and VWIL was misplaced. The court held that the Fourth Circuit's substantive comparability standard was a displacement of the court's more exacting standard, requiring that all gender-based classifications today be evaluated with heightened scrutiny. When evaluated with such heightened scrutiny, Virginia's plan to create the VWIL would not provide women with the same opportunities as VMI provides its men, and so it failed to meet the requirements of the Equal Protection Clause. As a note, Justice Ginsburg announced of the court's opinion may be considered an address to the American public. It is a plain-spoken and forceful summary of the majority position. Quote, "This case concerns an incomparable military college, the Virginia Military Institute, the sole single school among Virginia's public institutions of higher learning. Since its founding in 1839, VMI has produced civilian and military leaders for the Commonwealth and the nation. The school's unique program and unparalleled record as the leadership training ground has led someone in to seek admission. The United States, on behalf of women capable of all activities required of VMI cadet, instituted this lawsuit in 1990, maintaining that under the Equal Protection Clause of the 14th Amendment to the United States Constitution, Virginia may not reserve exclusively to men the educational opportunities that VMI affords. This case has a long history in court. In the first round, the district court ruled against the United States, reasoning that the all-male VMI served the state policy according a diverse array of educational program. The Fourth Circuit vacated the judgment, concluding that a diversity policy serving to favor one gender did not constitute equal protection. In the second round, lower courts considered a found satisfactorily to remedy Virginia proposed a program for women called the Virginia Women's Institute for Leadership, or the VWIL, at a private women's college, Mary Baldwin College. A VWIL degree, at the Fourth Circuit said, would not carry the historical benefits and prestige of a VMI degree, and the two programs differed markedly. In methodology, VMI is vigorously adversative. VWILs would be cooperative. But overall, the lower courts concluded these schools were sufficiently comparable to meet the demand of equal protection. We reversed that determination. Some women can at least meet the physical standards VMI imposes on men, are capable of all activities required of VMI. Cadets prefer VMI's methodology over VWILs, could be educated using VMI's methodology, and would want to attend VMI if they had the chance. With recruitment, the district court recognized VMI could achieve at least 10% female enrollment, a number the district court said sufficient to provide female cadets with a positive educational experience. If most women would not choose VMI's adversative environment, many men too would not want to be educated in VMI's environment. The question before us, however, is not whether women or men should be forced to attend VMI. Rather, the question is whether Virginia can constitutionally deny to women who have the will and the capacity the training and attendant opportunity VMI uniquely affords, training and opportunity of the VWIL program does not supply. To answer that question, we must have a measuring rod, what lawyers call a standard of review. In a nutshell, this is the standard our precedent establishes. Defenders of sex-based government action must demonstrate an exceedingly persuasive justification for that action to make that demonstration. The defender of a gender line must show at least that the talents classification served important governmental objective and that any discriminatory mean employed is substantively related to the achievement of those objectives. The heightened review standard applicable to sex-based classification does not make a proscribed classification, but it does mark as presumptively invalid, incompatible with equal protection, a law or official policy that denies to women, simply because they are women, equal opportunity to aspire, achieve, participate in, and contribute to society based upon what they can do. Under this exacting standard, reliance on overbroad generalization, typically male or typically female tendency estimates about the way most women or most men are will not suffice to deny upon to women whose talents and capacity place them outside the average description. As this court said in Mississippi University for Women against Hogan some 14 years ago, state actors may not close entrance gates based on fixed notions concerning their roles and abilities of males and females. A remedial decree must two of the constitutional violations in this case. The violation is the categorical exclusion of women from an extraordinary educational leadership development opportunity afforded men. To cure that violation and to afford genuinely equal protection, women seeking and set forth a VMI quality education cannot be offered anything less. We therefore reverse the Fourth Circuit's judgment and remand the case for proceeding consistent with this opinion. The Chief Justice has filed an opinion concurring in the judgment. Justice Scalia has filed a dissenting opinion. Justice Thomas took no part in consideration or decision of the case. Once again, this was Ruth Bader Ginsburg on June 26, 1996, via the opinion announcement for United States v. Virginia. Thank you for listening. Hip Hop League.